Good morning, everybody. Welcome to HTI, our quarterly learning series. This one particularly focusing on the upcoming FLSA changes. So we have brought in an employment law expert, Mr. Chase Samples. Chase is a state and federal employment litigator with Jackson Lewis. He received his undergrad from Furman University, and we have some proud Furman grads here as well, and went to law school at University of Georgia. With the deadline approaching, we wanted to give everybody another opportunity to ask some final questions and for Chase to share some examples, perhaps on best practices. So with no further ado, Mr. Samples.
Well, good morning, everyone. Good to be with you. Is this coming through? Okay, all right. I'm debating on whether to sit or stand. I think I'll start by standing. I understand that this group has already heard one presentation a few months back about the overtime regulations, and so I thought what we would do today, we'll touch a little bit on the basics and kind of review what was covered last time, but I thought our time would probably be best spent focusing on kind of putting this stuff into action and the questions we've been getting on a day-to-day basis from clients who are struggling with, okay, how do we do this? We know what the rules are, now what does that mean? So I like to think of this, if the last session was kind of the overtime regulations 101, this is overtime regulations 102, just kind of, how we actually put this stuff into practice. But before we kind of get into that, I will do sort of a high-level overview of the overtime regulations. Hopefully everybody in this room has heard that effective December 1st, the Department of Labor is increasing the salary threshold for the white-collar exemptions to $913 a week. I mean, at its most basic level, that is the primary change, but that's a significant change given that, the prior salary threshold was less than half that amount at $455. So this is a significant increase from about $23,000 a year up to over $47,000 a year. What that means is that if you have employees who you've treated as exempt and they're earning less than $47,000 a year, you need to take a look at those positions and evaluate whether those people are still exempt and whether, how and whether you need to change their pay. A couple of other things about the regulation, and I think most of you probably heard of this, but in addition to increasing the salary basis test up to $913 a week, the new regulations also added a requirement that the regulations are going to be updated automatically every 3 years. And so, we're going through this process now. We'll be going through this process again in late 2019. So effective January 1st, 2020 is going to be the first automatic increase. And that increase is going to be tied to the average wage earnings in the lowest economic region, which currently is the South. So it's basically 40% of the average income from the lowest geographic area. So that's kind of indexed to that. So I guess the good news is originally as proposed that change was going to have to occur every year, but we get at least 3 years with the current regulations. Another unique aspect of the regulations is that for the first time ever, you can actually count 10%. You can get a credit, I guess, of up to 10% of the person's earnings in the form of bonuses and commissions. So whereas before the salary, the $455 a week had to be pure salary, you couldn't include any commissions or bonuses in that. Now you can include up to 10%. So, it's $913 a week, that's $91.30 of that $913 can be bonuses and commissions. So that's kind of the basics. A little bit of review about kind of which exemptions we're talking about, because if you're familiar with the Fair Labor Standards Act, there are all kinds of exemptions. And we're just dealing with the white-collar exemptions, which are actually the most common, and they're ones that, any employer of any size has people classified under one of these exemptions. So it's an exemption. These are exemptions that touch on a lot of people, but they're typically called the white-collar exemptions. And they're divided into 3 different groups: the executive, the administrative, and the professional exemption. Now, in addition to the salary test, there are kind of 3 requirements that have to be met before a person is exempt. And I apologize if this is a review or basic information for y'all, but I want to make sure we got the foundation before we try to apply it. With the executive exemption, you have to pay the person on a salary basis. That's the first requirement. Second requirement is that salary has to be at least $9.13 a week, effective December 1st. And the third requirement, which has not changed, is that the duties test must be met. And there's a duties test for each of these three different categories of exemptions. The executive is probably the most common. That's your supervisors and managers. Executives have to supervise 2 or more full-time employees. They have to their primary duty has to be managing the enterprise or a part of the enterprise. And they have to have essentially the authority to hire and fire or recommend that people be hired or fired. So that's the executive. That's the most common. That's I think one of the easier white-collar exemptions to apply. The administrative is one I think we're going to be looking at a lot more with these changes, but it's a little more ambiguous. With the administrative people, we're talking about non-manual folks whose primary duty, again, is management. But these people don't have to supervise 2 or more full-time employees, but they essentially do have to lead up a department. These are your key upper-level managers, senior executives, people who are really kind of driving the ship, making important decisions about the direction of the company, or at least important decisions about the area in which they oversee. And then the third is the professional exemption. And there are lots of different nuances within the professional exemption. At its most basic level, I guess you have two different types. You've got creative professionals and learned professionals. Within each of those groups, especially in the learned professionals, you've got lots of different special rules. The learned professionals are those people who have gone to school and gotten a degree that they're actually applying in their job. That's lawyers, doctors, engineers, professional types. That encompasses a lot. I will say that lawyers, doctors, and teachers are professionals, but they're not affected by the new salary increase because they've never been subject to the salary requirement. So if you've got an in-house lawyer, I hope you're paying them $47,000 a year. But if you're just making them slave away and they aren't paying them that much, you don't have to worry about it because they're not covered by it. So I guess the thought is lawyers should be able to take care of themselves. Same thing with doctors. If you have a doctor on staff, they're not subject to that salary requirement. Teachers as well, and there are going to be a lot of teachers who earn less than $47,000 a year, and that's okay going forward. They're not subject to that salary increase. So, and again, that's just something that wasn't something that was carved out of these regulations. That's just something that's been in place for a long time. That was part of the original regulations that teachers weren't subject to that. So those are kind of the three different types of white-collar exemptions. One other category of exemption that was also affected by this are your computer employees. Computer employees, there are kind of two salary requirements. Previously you could have either paid them a weekly salary of $4.55 a week, or you could pay them an hourly rate of, I don't have to look at this often, it's $27.63. So there's two options for paying your computer employees, and this is, when we're talking about exempt computer folks, we're not talking about people who are working at the help desk, people who are troubleshooting, those kind of folks. We're talking about your software engineers, people who are programming, folks who are doing, I guess what's thought of as more high-level computing. Those are your computer exempt employees. But those folks, if you were previously paying them on a salary basis, that salary basis has increased. So it's gone up from the $4.55 to $9.13. So let's not forget about the computer folks when we're taking a look at this. Any questions about kind of which categories of exemptions we're talking about? And I should have said this at the outset, but I want this to be interactive. I know we've got some folks who are tuning in online. Feel free to submit questions and I'll field those. I want this to be an interactive discussion. Otherwise, y'all are going to be bored after half an hour of hearing me talk. So once I get through the basics, I'm gonna give you go through some frequently asked questions that I've been getting. But I want to hear your questions. So this is a chance for some free legal advice. So take advantage of it. The other question, the other thing that folks have been asking is this really going to take effect on December 1st? Because a lot of companies have been in denial You know, the lawyers have been saying, yes, it's going to happen, prepare, but everybody's been thinking, no, surely not. I mean, this is just too much. This is going to hurt too many businesses. Something's going to intervene, either Congress or the courts, and undo this. In my opinion, that's not going to happen. I mean, now we're less than a month away. There has been legislation proposed in Congress. President Obama will veto that legislation, so that I think the legislative avenue is closed, and I don't think they're going to be able to override the veto, especially this time, you know, given the season we're in, and with a lot of lame duck representatives. I just don't see that happening. I think the more likely avenue of success, if there is one, and I don't think it's likely. So again, I think we got a plan for this. I think it's coming, but there are 2 lawsuits that were filed in the Eastern District of Texas. And the lawsuits were filed there very strategically because the Eastern District of Texas is very pro-business generally. There was one suit filed by 21 states, including South Carolina, challenging this as it applies to public employees. And then there was another suit filed by the U.S. Chamber and a bunch of other business interest groups challenging it on behalf of private employers. Those 2 cases have been consolidated. However, I guess the parties drew kind of an unfortunate draw in the judge. It's an Obama appointee who is hearing these cases. He's relatively new to the bench, but I think it's unlikely that he's going to do anything to upset this. So that's just my personal opinion. There is a hearing set for November 18th. They've moved for a preliminary injunction to stop this. That hearing is November 18th. There's also a hearing set for November 28th to rule on the overall merits. So if we get a decision, it's going to be in the midnight hour. But again, I think it's unlikely. I think we've got a plan for this thing going forward. So I guess one thing that folks that are just hearing about this have been asking is, well, where should I start? What should I do? And, you know, I tell folks, well, first of all, generate a list of all the people in your company who are paid on a salary. And I'm not talking about exempt versus non-exempt. I'm talking about folks that you're paying now on a salary. And obviously, if those folks that are on that list are making less than $47,500 a year, approximately that amount, those folks are going to have to either bump up their salary to keep them exempt, reclassify them as hourly, or there's some other options, and we'll talk about those later. But you're going to have to do something with respect to those folks. For those people who are making more than $47,476, I think you ought to take a look at those folks too. I think this is a great time to kind of do an audit of all of your salaried employees. And a lot of clients are doing this, and I'm getting at least 1 call a week now. And I can tell you, every call I've had, we are finding employees who've been misclassified. And this is a great opportunity to fix that, because you've got the excuse or the guise of operating under the new regulations. And so as you're rolling this out to all of your, you know, as you're making changes to all of your salaried employees, you can also make changes to those who perhaps were misclassified before. So this is a great opportunity to do that. Now, it's not going to completely shield you from liability if one of these employees comes to you and says, well, you know, why wasn't I hourly before? Why are you just now giving me overtime? And I think the response is going to be, well, you know, look, the regulations have changed. The Department of Labor has made some changes, and we've reviewed those changes, and based on our review, we think you're no longer exempt. Hopefully the questioning stops there, but there always is that risk that those employees could do some research and find out, well, hey, maybe I should have been paid overtime for the last 2 years, or perhaps the last 3 years. So that is the risk in reclassifying, but I think this is a great opportunity to do it. And I mean, I always tell people anytime, not just now, but if you've got employees that are misclassified, you're engaged. I mean, the liability is continuing to grow day by day. So go ahead and fix it. But this is a great opportunity to make those changes.
Chase, I have a question.
All right.
If you could repeat it after I ask it so that it gets picked up on the mic. As it relates to, I mean, we live in a very technological society now, right? So those people that will be classified as non-exempt that might get work emails on their phone, how is that going to be looked at after they leave work?
Yeah, that's a great question. That's something we're dealing with now. So the question is, what do we do about those employees who we're going to reclassify as non-exempt? But these are folks that have been used to responding to emails after hours. I mean, they've been used to being exempt. They haven't been tracking their time. What do we do about that? Because I mean, the reality is, if those folks are working, and working includes responding to emails, taking phone calls, whether it's at the office or not, it's still work. You as the employer are responsible for paying them minimum wage and overtime for that work. So if they're exempt, if they're currently exempt, they haven't been used to tracking their time. And we've seen this in other industries. I'm actually defending some litigation now in the timeshare industry, where several years ago timeshare industry reps were exempt. They're no longer exempt. And those folks have been used to doing, working whenever they can, calling folks after hours, chasing down the sales. And so it's very difficult to get to kind of retrain those folks to start tracking their time, but you got to do it. So that's part of the rollout, is if you have some employees who you are going to reclassify from exempt to non-exempt, you've got to emphasize, okay, now you got to start tracking your time. And I think you can spin this in a positive light. Before, look, we could make you work as many hours as we wanted you to, and you got paid the same. But if you're being paid hourly now, you can pitch it as, hey, you're now eligible for overtime. So you ought to want to record this time. And so, you need some procedures in place. It depends on your operations. There's several ways companies now are doing this. If you have like a time clock, you want to make available like a time edit form or something where you can make adjustments to that time for people who work off-site. And you want to encourage people that, if they're responding to emails after hours, they need to report their time. Now, let me back up a little bit. I think the better practice is to start, if you can do this, and it really depends on the needs of your business, but if you can have these people not respond to emails and phone calls after hours, that's the better practice. And if there is a way that you can limit their email access after hours, again, that's going to insulate you a little bit. So if the needs of the business will allow it, and you can tell these people, look, we only want you working when you're here. We don't want you responding to emails. We don't want you making phone calls. And if you're doing that, you're working off the clock, you're subject to disciplinary action. That's the safer practice, but I understand that especially with a lot of these people who have been exempt, it's not going to be practical to tell them they can't respond to emails or they can't take phone calls. So from a practical standpoint, you need some procedure or method in place to capture that time. And you got to be, it needs to have some teeth to it. If you catch somebody responding to emails and not reporting their time, you need to discipline them for it. That's going to be your best defense in the event, you're faced with a lawsuit down the road. But that's a great question. That's something that I think we're going to be dealing with that, well beyond December 1st. Because currently, what keeps me busy now, I'd say 2/3 of my time is spent on FLSA litigation. And most of that FLSA litigation is off-the-clock claims. So these are some of, and part of the reason that I spend so much time doing it is because there are so many of these cases. These cases are easy to bring as class actions. But it's also very difficult for an employer to defend against these types of cases because it's a he said, she said situation. So it's not the type of case you can get the court to throw out on a dispositive motion. These are cases that are headed to the jury unless they settle, and most of the time they settle. But you want to do as much as you can to insulate yourself from those types of off-the-clock claims. But that's a great question. Let me just go through real briefly kind of the options. So you've got some employees who are falling below the line. What are your options? Well, first of all, you could bump them up above the new salary threshold. If you want them to remain salaried exempt, that's really your only option. If they're making less than $913 a week, you bring them up to $913 a week. Now, I understand you're going to have folks that aren't close to the $47,000. So for those folks, you've got to look at other options. And another option is to reclassify those people as hourly and start paying them overtime. Now, a couple of things I'll mention on this, if the person has been working 50 to 60 hours a week, I wouldn't take their salary and divide it by 40 hours to figure out what their hourly rate's going to be, because otherwise you're going to wind up paying them a lot more than you're paying them now once you start paying them overtime. So think about that as you're trying to decide how you set the hourly rate, and factor in if they generally work an average of 50 hours a week, then set the salary based on 50 hours, including the overtime, and then, or set the hourly rate based on a 50-hour work week. That way, you're not paying them a lot more than you're currently paying them. Another, I guess I touched on already some of the other difficulties when you're making that switch from salary to hourly. I've been hearing a lot of companies say, well, that's going to really hurt employee morale because I think this is true. There is a certain amount of status that comes with being a salaried employee, and there's a certain amount of status that comes with not tracking your hours. And some people may be upset if they're going to have to start doing this. And the good news is you've got a scapegoat, so you can point the finger at the Department of Labor, at the government, saying this is something that we have to do. We don't have a choice. But then, like I mentioned a moment ago, I think you can try to pitch it as good news and say, look, now you're eligible for overtime. But you're going to have to do some training to these folks in terms of tracking their time because they're not used to doing it. Now, one of the questions that came in before, and it touches a little bit on the last question, but it's, how do we record this time? Are there any requirements in the regulations about how time should be recorded? And the answer to that is no. The time just has to be recorded accurately. So the Department of Labor doesn't give us specific guidance about here's how you do it. I mean, obviously you can use a time clock. If you've got current exempt employees, a lot of these folks are going to be folks that work at a desk. They have computer access. You can use a timekeeping system on the computer, have them report their own time. It's not required that they clock in and out. And you can have them actually record their time. I would recommend they do that on a daily basis just to make sure it's accurate. But they can write down, I arrived at 8 o'clock, I left at 5. Took an hour for lunch. I mean, they can record those things themselves. It doesn't have to be an actual card swipe or a punch or something like that. The Department of Labor is just looking to make sure that this is accurate. And obviously, we want to have records if we're paying these people hourly. You want to maintain those records for 3 years because that's how far the department can go back, or a private plaintiff can go back if they bring a lawsuit. So your best defense is going to be having those records. Now, one thing a lot of companies will do is have employees review that time on a weekly or bi-weekly basis or monthly, just depending on your pay cycle, have them review their time and sign off on it. I think that's a good idea, especially for folks who have not been used to tracking their time. It gives you a little bit of extra protection that, in addition to you reporting this time, you've also signed off on the fact that this time accurately reflects all the hours you worked. You just have to be careful. And this is part of our jobs as HR folks and managers, owners of businesses. We've got to train the managers a little bit, because if managers have the ability to make edits to the time, there's always the risk that some rogue manager is going to cut somebody's time so they don't have to pay them overtime. And that's a problem we've always had, but it's going to continue. It's going to be a problem that continues as you have folks who are working a lot of overtime. So be sure we train, our managers, and especially those that have the authority to make edits to time, that, we pay for all time worked. Now, if you have a policy that says, and a lot of folks do, that all overtime must be approved, that's fine. And if somebody works overtime without approval, you can take disciplinary action, but obviously you still have to pay them for that time. So we don't want to cut their time. If they worked it, we pay it. If they worked it without your permission, you can take disciplinary action against them. Another option, and this is one that I've been talking with folks a lot about, is continuing to pay these folks on a salary, but make them eligible for overtime. So it's sometimes referred to as salaried non-exempt. And a lot of people like this because the folks are used to getting a salary. So you're not really changing that, but you're making them eligible for overtime. Now, this gets a little tricky, so bear with me. There's a couple of ways you can do this. One, first of all, I would say you need a written agreement to protect yourself. The regulations say a clear mutual understanding. To me, that needs to be in writing. So if you're going to have a salaried non-exempt employee, you want a written agreement with them that says, this is your salary, and this is the number of hours that this salary covers. Some folks tie that to 40 hours, but if you've got an employee who's working 50 hours a week now, you can say, okay, this is your salary, and this salary is intended to cover 50 hours. But, now bear with me because I want to make sure we get this right, because like I said, this can get tricky. For hours 40 to 50, you're going to have to pay an overtime premium, but it's only a half-time premium. It's not time and a half, because the salary is intended to cover up to 50 hours. So they're already getting an hourly rate for hours 40 to 50, but you still have to pay them a half-time premium for hours worked between 40 and 50. Now, if you had the more common agreement, which is this is your salary, it's intended to cover 40 hours, and somebody works 42 hours, you've got to pay them time and a half for those 2 hours. So it really depends on what your agreement is, but I like this option because it gives you, especially if you have folks that usually work 50 hours, it gives you the opportunity to just pay halftime on the overtime. Question?
Yes, Chase, how do we distinguish between when we have sort of what we call after-hour events people want to come to, but they're not necessarily required to come to? In other words, we may have a social here from 6 to 8. Everyone in general comes. When they're here, they may help set up shit or something. But technically, I guess they're not required to be here. How do we monitor that?
Well, if it's not required and, them helping set up or whatever is completely voluntary, then you don't have to pay them for it. That's not work. But if it's one of those things that, this is voluntary, wink, wink, but if you're not here, you're going to be, you're not going to get a raise. Those are the kind of things you have to be careful about. Now, if it's a social event or party, I'm less concerned about it. This is more of a problem for training and things like that, where companies will try to bring folks in and say, oh, well, the training was voluntary, but it really wasn't. So for social events, I'm not too concerned about it. But again, it does need to be voluntary, and there shouldn't be any consequences if the employee decides not to come. But,
one more question.
Mm-hmm.
You might want to repeat it. How about travel time? If we go to Charleston and spend 2 nights, how do you stop the overtime? When does it clock?
Yeah, that's a great question. And travel time is tricky, and travel time really depends on the industry you're in. Generally speaking, I'm going to generalize here, and I would encourage you to look at each position and kind of what they're doing. If the travel, it depends on the position, and we could talk for 30 minutes about travel time. Generally, the travel, if it's outside of what they normally do, the travel should be compensated if it's required. And we're talking about hourly employees. Now, your exempt folks, you don't have to worry about it. But for hourly, and this is going to become more of an issue because you're going to have folks who travel who've been exempt that are now going to be non-exempt. If they're traveling from their normal workplace to somewhere outside of where they normally travel, that travel time should be compensable. And that travel time is included, in the number of hours worked, so it's going to count toward overtime. Now, if you have a work site that, if you have different work sites and it's more of commuting, I guess commuting time generally is not compensable. So it really, again, it depends on the nature of the work. And if they're the kind of person who normally travels from job site to job site, you've got a better argument that travel time doesn't need to be compensated if they go from home to work and their work is at a different site every day. But if they normally have a central office where they work out of and the travel is kind of unusual, that's going to be compensated. Now, there's a lot of gray area in between there, and I would encourage you to take a look at that, maybe talk with your counsel about that. That's a good question. Another option, kind of going back, and I think I forgot to repeat that question. I'm sorry. That's twice in a row I haven't repeated the question. I'll try to do better next time, but that was a question about travel time. Another option, actually, before I move on, because again, salaried non-exempt is tricky, so I want to make sure we get this right. It has to be a fixed salary. So if you say this salary is intended to cover 50 hours and the person only works 35 hours that week, you still have to pay them the full salary. So that's the trick with this. It really does need to be a fixed salary. Now, if somebody works, if it's intended to cover 50 hours and they only work 45, you still pay them the salary, but you only have to pay them the halftime premium for 5 hours of overtime. So that overtime premium is going to fluctuate depending on how much they work each week. But it is important that that salary actually be a fixed salary. Another option option that we've kind of been hesitant to encourage folks to use, but that has really been gaining in popularity over the last few months is what we call the fluctuating work week method of payment. And that's similar to what I was just talking about, except with fluctuating work week, you've got the requirement that somebody's hours actually really do have to fluctuate from week to week. With that person, you can have an agreement with them that the salary you pay is intended to cover all of the hours that they work. But as I mentioned previously, you still have to pay in overtime a half-time premium for hours worked over 40. Now, there are some limits. I think you can't, it can't cover more than 60 hours a week. So if you've got somebody who really is working a lot of hours, you know, the Department of Labor doesn't want you taking advantage of this option. But again, just like with the prior salaried option, that it's a fixed salary, and so no matter how many hours they work in a week, you still have to pay them that fixed salary. Now, there are some exceptions. There are some, well, I'm not going to go there. Never mind. Any questions about that option before I move on? Because that would, a lot of people are trying it. I think it's a good option if done correctly, but it's very technical, and it's, you know, you want to make sure you get it right if you decide to go that route. Other options that we don't always talk about, but that are certainly on the table, are, you know, reducing an employee's hours. If you've got somebody who's currently exempt and you're going to reclassify them to hourly, you can reduce their hours to 40 so you don't incur any additional cost. Now, that can be a challenge depending on the position. You may have to shift some work around. You may have to hire more part-time employees. But I don't want folks to lose sight of that as an option. You know, you can shift work around, move duties around. It's a little trickier, but if you want to try to control overtime, that's certainly an option as well. So those are kind of the basic options for, you know, for how you might respond to this. So I thought what I'd do with the half hour we have left is talk about some specific questions I've been getting as, you know, we're putting this into practice. What does this really look like? And this is really where I want this to be an interactive discussion. So if y'all have questions, please raise your hand. I think we've got one in the back.
Yeah, we do actually have one online. So if someone is paid as salary exempt, they would still have to clock in and out and track their time, correct?
Yeah, so the question is, if someone is paid as salaried exempt, or salary, I think maybe it means salaried non-exempt. If they're salaried non-exempt, do they still have to track their hours? And the answer is yes, because you've got to pay them overtime for hours worked over 40. So yes, even with that option, you are going to have to change their behavior and get them to start keeping track of their time, because you need to know whether they're working overtime or not. So any of your non-exempt employees, even if they're paid on a salary basis, you still have to track their time. That's a great question.
They had a follow-up. So how is the rate calculated? Is the salary divided by the number of hours agreed upon?
Yeah, that's a great question. So the question is, how is the rate determined if you have somebody who is a salaried non-exempt employee? The regular rate, and this is a term of art under the FLSA, but the regular rate is what's used to determine the overtime rate. The regular rate in that situation is determined by dividing the salary by the number of hours it's intended to cover. So if it's 50 hours, you divide the salary by 50 hours. No matter how many hours they work, that's how you calculate the regular rate in that situation. But that's a good question. That's one of the ones I've been getting. Actually, I think that may have been on my list. Any other questions about that before I move on? One question that we've been getting is, well, when should I implement this change? And obviously, a lot of you have probably already thought about this because we're so close to December 1st. The only requirement is that effective December 1st, you start doing this. So depending on what your payroll cycle is, you might want to start it a week early or 2 weeks early just to make sure that you're on track. But after December 1st, you know, as of December 1st, you have to be paying folks the correct way. So, you know, it's really a business decision as to when you start doing it. You could start today. You could have already started, or you can wait until December 1st to start doing it. So that's one question folks have been asking. Another question is the 10%. Before I get to that, though, some people have been asking, well, can we count benefits and other things in this salary? Because we've got a really good benefits package. And the answer to that is no. A salary basis is a salary. And it's you know, common sense, but you're paying them, you know, numeration for the work that they do, and it's paid usually in the form of a paycheck. you can't count medical benefits, can't count retirement benefits in that salary when you're looking at the $913 a week. And that kind of leads into my next point, which is this new 10% option that we have. Now, this doesn't really give you a lot. So this is, if you've got employees that need through bonuses, commissions, this really isn't going to help you out very much. But it could help you out a little bit. So if, I don't think I would recommend to folks, if you don't already have a commission or bonus plan in place, I don't think I would recommend creating one just for this 10% purpose to try to get some benefit out of it. I don't think it's going to be worth it. I mean, we're talking about $91.30 a week. But if you already have folks who are bonus eligible or generate commissions, for those folks, you can take advantage of this 10%. Now, so here's how it works. The DOL says you can take a credit for that $913. You can take a 10% credit for any bonuses, commissions, and incentive pay. And let me say on the bonus piece, I should have said this earlier, the bonuses have to be non-discretionary bonuses. That doesn't include discretionary bonuses. So a discretionary bonus is one where the employer decides how much and how often to pay it or if to pay it. Non-discretionary bonuses are those that are typically pursuant to some type of plan where if you do X, you're going to get Y. You do X amount of, generate X amount of revenue for the company, this is your bonus. Those are non-discretionary bonuses. So for the 10%, we're only talking about non-discretionary bonuses, not discretionary bonuses. I'll make sure we get that right. But when you're looking at the 10%, it's looked at on a work week basis. But the Department of Labor says every quarter, at least quarterly, you can make. I think I said that wrong. I want to get that. No less often than quarterly. So you can look at this once a month. You can look at it quarterly. You need to make sure you're actually paying these people $913 a week. So if for whatever reason a person doesn't generate $91.30 in bonuses and commissions in a certain week, you have the option to make a catch-up payment to keep those people exempt. That catch-up payment needs to be made at least quarterly. You can do it monthly. You can go back and look at the end of the month and say, well, did this person get their $91.30 each week and make the payment then? Or you can do it at the end of the quarter. If you're making a catch-up payment, that catch-up payment has to be made no later than the next regular payday. So if they're paid bi-weekly, you would pay them 2 weeks after the quarter end. Question?
Doing the catch-up payment, can you do it like a draw? For instance, you put $1,000 in to catch them up in quarter one. In quarter two, they're going to pay $1,000, but you don't pay it because you had already pre-paid that to catch them up for quarter.
Yeah, the question is, can you do the catch-up payments kind of like a draw? So if somebody has a slow quarter, they don't generate enough commissions, but say the next quarter they generate more than enough, can you essentially give them a draw and then take that draw back next quarter? And the answer is yes. But I would want to have an agreement with the employee about being able to do that. It's not unlike draw payments currently, but yes, you can take it back. Again, I'll say that a lot of employees don't like those kinds of situations, and we've seen a lot of litigation over them, but technically you can do that. Another question folks have asked related to that is, how do we define the quarters? And the good news is, I guess, the Department of Labor lets the employer define the quarter however they like. I mean, it needs to be a 3-month cycle, but it doesn't have to necessarily be calendar quarters. If your payroll system is set up on a different quarterly system, you can use that system. It just has to be quarterly and consistent. It doesn't matter when the quarter starts or when it ends. Any other questions about that 10% catch-up option? One question that somebody has asked is, well, what about terminated employees? If we terminate an employee and we're looking back at their recent weeks and they don't quite make the $913 a week, do I have to catch them up upon termination? And I think the answer to that is yes, or else you risk losing the exemption. So keep that in mind. If you're terminating someone who's paid this way and you're using the 10% catch-up, make sure that when you terminate them, they've actually earned $913 a week, because, as y'all know, the employees who you've terminated are the ones who are actually going to go and talk to lawyers and try to sue you. So, you know, they're going to, now, you know, it's becoming more and more common where lawyers will say, you know, somebody will come in and say, oh, well, I was discriminated against based on my age, or this was, you know, this was all a gender discrimination. And the lawyer will press them a little bit and see, and then the lawyer might decide, you know, this is really a weak case for age discrimination, or this is a really weak case for gender discrimination. But how are you paid? Tell me a little bit about how you were compensated. Bring in a couple of your latest pay stubs. And it's really easy for those types of claims to be asserted. So somebody may decide not to sue you for discrimination, but sue you for some type of wage claim. So do be aware of that. For terminated employees, you do want to catch them up if they haven't made the 913 a week. Another question I've been getting is with respect to the highly compensated employee exemption. So let me talk about that for just a few minutes. This is kind of a different exemption. Previously, anybody who earned over $100,000 a year and satisfied what was really a minimal duties test, they just had to, you know, if they were an executive, they might not have to supervise 2 or more full-time employees, but their primary job could be managing. That would be enough for them to satisfy the highly compensated exception. So if you have some people who are currently classified as highly compensated because they're making over $100,000, that number has now gone up to $134,004. So $134,004. With those folks, again, I would take a look just to make sure that you really are having to rely on the highly compensated test, because a lot of times if you have folks who are making more than $100,000, chances are they're going to satisfy one of the other duties tests, either executive or administrative. But if you really are having to rely on sort of the nominal lighter test for highly compensated, for those employees, you're going to have to either bump them up or go with one of the other options we discussed earlier. So just be aware of that. One good thing about the highly compensated exemption is you're not limited to this 10% catch-up, and this has always been the case. Now, highly compensated employees are subject to the same salary test as other exempt employees, 913 a week. But obviously, 913 a week is not going to get you to 100,000 or 134,000. Those folks can rely a lot more heavily on commissions and bonuses to get them to that salary threshold. So for the highly compensated employees, you just have to pay them 913 a week, minimal duties test, and they can rely on more non-discretionary bonuses and commissions to get them over that $134,000 threshold. And with those folks, you have the option annually to make a catch-up payment. So at the end of the year, you can look back, and if somebody didn't generate as much in commissions or bonuses as you expected they would, you can catch them up at the end of the year and keep them exempt. So that one's a little more relaxed. I mean, obviously, the Department of Labor is not as concerned about people who are making over $100,000 as they are, you know, people who are making half that amount. So not as many protections in the statute. Any questions, comments about the highly compensated exemption? I touched on this earlier, but it's another question that I've been getting is, should I be concerned about salaried employees who are making more than $47,476? And the answer again is yes. This is a great time to take a look at those other salaried positions to make sure they really are exempt positions. You know, we haven't had, I mean, it's been 15 years since we've had an opportunity like this to really fix classification issues, and this is a great time to do it. I mean, I'm talking to even sophisticated clients who have full-time human resources folks and payroll departments that are discovering that, you know, for whatever reason, we've got 1, 2, maybe 10, 20, 30 people who have been misclassified, and this is a great chance to fix that. Other questions, comments? Yes.
This is a terrible question. I apologize for asking, but I've heard it. Earlier you mentioned benefits. So if you take an employee and you move them from 42 to 47, can you then say, however, we've been paying $400 a month towards your health insurance. We're going to stop that payment and give you the opportunity to buy that?
Okay, so the question is, and I want to make sure I understand your question. If you've got an employee who's below the threshold now, but you want to essentially bump them up above the 47,000. But as part of bumping them up, you're essentially going to tweak their benefits so that instead of you, the employer, paying their portion of the health insurance, you're going to require them to pay it. Yes. And yes, you can do that. Again, and some employers are doing that. I mean, if a lot of companies operate with thin margins, and so you got to kind of rob from Peter to pay Paul. And it's a lot of companies are looking at how we can adjust benefits to, if we're increasing the salary, how we're going to adjust our benefits, and that's okay. You can do that. Like I said before, you can't count benefits as part of salary. The government is sort of assuming that there's no requirement to provide those benefits. So, well, I shouldn't say that. Obamacare changes that, but I'm not going to go there. I'm a wage and hour lawyer. You don't want me to talk about Obamacare. Yes, you can make adjustments to benefits. It doesn't have to be health insurance. It can be retirement benefits. If you were doing a matching 401k before, you could stop that and instead bump up their salary and make them pay more of their share of that.
You have to do that straight across the board to all employees.
Yeah, the question is, do you have to do that across the board to all employees, or would it be discrimination? And that's a great question, because you need the employee benefits when you're making those types of changes. And that's another point too we haven't really touched on, but as you're starting to reclassify folks from exempt to non-exempt, those employees may be losing some benefits that they had before, and you may not want them to lose those benefits. So in addition to just looking at your pay records, and I'm really glad you brought this up, you need to take a look at your benefit plans and see what your benefit plans say, because you may be doing more harm than you realize to those employees. And obviously, if you have an ERISA plan or a plan that has certain IRS qualifications and requirements, you want to make sure that that plan is not discriminatory. So you do have to be careful in how you make those types of changes. But that's a very good question. Don't forget to take a look at your benefit plans as you're looking at these issues too. So this is really, the more we dive into this, the more we realize that though this was a pretty simple change on its face, it touches on so many aspects of the employer-employee relationship, and there's, there are intended consequences that we're realizing, and then I think there's going to be some unintended consequences that we'll be dealing with down the road. Another one to think about is if you're bumping somebody up, well, what about the person who's supervising them? Do I need to bump them up too? Obviously, you want to watch out for employee morale issues. You don't want a supervisor making less than their subordinates, and that could happen with these new requirements. So give some thought to that, especially as and hopefully you'll have already done this, because we're getting so close. But I still run into employers every day that are saying, what is this? Where did this come from? Why haven't I heard about this? So, well, you haven't. I guess you're not getting our emails. But folks are still realizing that this is something that's going to have to be changed. But think about, not only how it impacts those employees that are making less than the 47,000, but what adjustments you're going to have to make across the company just to kind of keep the pay scale consistent and avoid any type of employee morale issues. Yes.
What method of timekeeping is FLSA compliant? They have an exact sales rep who's responsible for tracking time under the regulations, but the role requires answering emails at night and on weekends. So those are these friction methods.
Yeah, so the question is, this kind of touches on what I mentioned earlier, but what are the options for tracking time, particularly in the context of an inside salesperson? Before I get to that, I'll say with inside sales, you have to be very careful. The exemption is what we call the 7I exemption. It's very, very technical, very specific. And so if you do have somebody who's doing inside sales, you really want to, first of all, make sure they meet the requirements of 207I, the 7I exemption. Otherwise, you can't classify them as exempt. So I would encourage you first to take a look at that. And the Department of Labor's website, the Wage and Hour Division, has fact sheets that specifically spell out all the duties that are required for each of these exemptions, including the 7I exemption. So that's a great place to start. I know I covered those at the beginning, but if you have questions about the duties test, those are a great place to start. Now, I'll caution you that the DOL hasn't updated the salary numbers on those fact sheets yet. So when you look at those fact sheets, they're still going to say $455 a week. Obviously, you know that's changing, but those are still good resources as far as the duties test are concerned. But for that, going back to the question for those inside sales reps, if you need them to be doing the work, you need some option in place for tracking that time. You need some way of capturing it. And there's really no right or wrong way to do it as long as you're capturing all the time and doing it accurately. And that's really the challenge. So it can be a computer-based timekeeping system that tracks people when they log into and out of their computers, if they're using the computer for their job. It can be a manual entry system where they input that in using software. It can be an old-fashioned time card that they turn in to payroll every week. But you want to tell the folks that you're responsible for reporting all the hours that you work. And if you don't already have that policy in your handbooks, I would encourage you to take a look at that and maybe add it and say, the company specifically prohibits working off the clock. And you might even define working off the clock. Say working off the clock includes responding to emails and taking phone calls after hours. And you want to tell folks, we expect you to report that time because it's really to your benefit because you're going to get paid an hourly rate. Now, the sales positions are a little trickier because a lot of these sales folks are paid minimum wage. They're primarily depending on commissions to generate most of their revenue. So a lot of the sales guys really they don't care about the minimum wage. They'll tell you, well, I work for commissions. I don't care about minimum wage. And it's a cultural problem and kind of an attitude problem that we struggle with, but we still have to tell these people, look, we've got to track your hours. And if you're making phone calls, you need to report that time. And this kind of goes back to the draw question earlier. A lot of those guys are paid on the draw, and so they feel like every hour they're reporting is an hour they're going to have to pay back later. So with those guys in particular, you really have to make sure that you're capturing their time and disciplining them when they're not doing it. And that can be tough, especially if you've got a great sales rep who's working 7 days a week, making phone calls at all hours of the night and generating, $200,000, $300,000 of revenue for your company each year. It's hard to correct those folks, but there's a lot of liability for somebody that's making that much money. There's a lot of liability for overtime if you're not getting it right. So better to get it right on the front end. Yes.
So with like that, like occurrence or minute, or could that be covered under after hours for policy that you have? Which one would be better in that scenario? I mean, because it's hard to, I may look at an email and I may answer it, but it's like 2 minutes. So I guess it's sort of hard tracking by occurrence.
Yeah, that's a great question. I mean, the question is what do we do about these situations where somebody might spend a minute looking at and responding to an email? How do we capture that time? And there's no great answer. I mean, there is a de minimis exception in the law where if somebody does work for a de minimis amount of time, whatever that might be, that's a little vague, but you don't have to capture it. So if somebody spends a minute or two responding to an email, that's going to be de minimis. But, the problem is a minute or two can easily become 5 or 10 or 20. And so if you've got people responding to emails, I think you need to do all you can to try to capture that time and pay them for it. How you go about doing it, you could have a different system. So if there's somebody who clocks in and out and they're also doing some work after hours, you could have I see like time edit forms where they have to manually report it, or you could have a totally different system. If it's computer based, you could have a different computer system for tracking after hours time. And unless they're one of those folks that's paid on a draw, you want to try to pitch it to them as this is to your benefit. You're doing work for the company, we want to pay you for it. If we find you're doing work for the company and you don't tell us, we're going to have to discipline you for it. I think I've defended a lot of these cases, and that's the best defense that an employer can have to these types of cases is to say, look, we've disciplined X number of people for working off the clock. And I've got a case now where one of the named plaintiffs was actually terminated for working off the clock, and yet he's coming forth and saying, well, hey, I was working 70 hours a week. Well, that's not what you told us when we terminated you, because we knew you were working off the clock. We asked you how many hours you were working, and you said we paid you for all your hours. So that's a different story. But if you can point to people you've actually disciplined or terminated for working off the clock, that's a great defense to these types of claims. So any other questions? I think I've gone through just about all of my frequently asked questions. So hopefully, hopefully we've given you a lot of stuff to think about and work with. If y'all have questions, I'll stick around afterward. I'm glad to talk to you. I'm here in Greenville. Be glad to answer any questions you have. Another thing, I'll put a quick plug in for our firm is doing our annual client symposium next Thursday. So those who are here in Greenville and are interested, and especially if you need HRCI credit, it's next Thursday at the Poinsett Club for those here in Greenville. Starts at 8:30. I think it ends around 1. So we'd love to have y'all there. It's free. Breakfast and lunch are included. So that's my plug for the day. So I'll turn it back over. Thank y'all so much for having me. It's a pleasure being here.
Thank you, Chase. Good job. Hopefully everybody got a little bit of information today that'll help them make some key decisions moving forward. We appreciate everybody that came here in person and all of those that joined us online. Keep an eye out for some more updates that'll be coming from HTI. And like Chase said, if you'd like to stick around and network for a little bit, we'll be here. Thank you.